Hello aspirants, welcome back to my channel. Today we will study chapter 6 from Laxmikanth book, that is Citizenship. So let's begin our lecture. Okay. Basically, citizenship refers to the legal relationship between an individual and a state. It signifies full membership of a country. A citizen enjoys certain rights and privileges granted by the state and in return owes loyalty and allegiances to the nation. In India, citizenship is dealt with in Part 2 of the Constitution, covering Articles 5 to 11. These articles determine who became citizens at the commencement of the Constitution on 26 January 1950 and empower Parliament to regulate citizenship matters. Citizenship is important because it forms the basis of political participation, voting rights, public employment, and many constitutional privileges. Now we will discuss the concept of single citizenship. India follows the principle of single citizenship, which has been borrowed from the British constitutional system. This means that every person is a citizen of India only and not of any individual state. For example, a person living in Bihar, Maharashtra, or Tamil Nadu is simply an Indian citizen. Unlike countries such as the US, where people have dual citizenship, one of the country and another of the state. India has only one citizenship. Remember this, India has only one citizenship. This system promotes national unity, equality, and integration by ensuring equal status for all citizens throughout the country. Next is our constitutional provisions from Article 5 to 11. The Constitution originally laid down provinces regarding citizenship in Article 5 to 11. Article 5 deals with citizenship at the commencement of the Constitution. Article 6 concerns migrants from Pakistan to India. Article 7 deals with persons who migrated from India to Pakistan. Article 8 relates to Indians residing abroad. Article 9 addresses voluntary acquisition of foreign citizenship. Article 10 ensures continuity of citizenship. And Article 11 empowers Parliament to regulate citizenship through legislation. These articles were transitional provisions and mainly determined citizenship at the beginning of the Constitution. So let's start with Article 5, that is Citizenship Act Commencement. Article 5 specified who became citizens of India on 26 January 1950. A person had to possess domicile in India and satisfy one of the following conditions. First, he or she was born in India. Second, either parent was born in India. Third, the person had been ordinarily residing in India for at least 5 years immediately before the commencement of the Constitution. Thus, domicile and one additional qualification were necessary for acquiring citizenship under Article 5. Let's move to Article 6, that is migrants from Pakistan. During partition, millions of people migrated between India and Pakistan. Article 6 granted citizenship to persons who migrated from Pakistan to India. Those who migrated before 19 July 1948 automatically became citizens if they or their parents or grandparents were born in undivided India. Those who migrated after 19 July 1948 had to register themselves with the appropriate authority and fulfill residency requirements. This provision ensured protection and citizenship for refugees coming from Pakistan. Next is Article 7, which is migrants to Pakistan. Article 7 dealt with people who migrated from India to Pakistan after 1st March 1947. Such persons were generally not considered Indian citizens. However, an exception existed. If a person returned to India under a permit for resettlement or permanent return, he or she could regain Indian citizenship according to prescribed procedures. Thus, Article 7 prevented automatic citizenship for those who left India for Pakistan but provided an opportunity for returnees. Next is Article 8, Indians residing abroad. Article 8 provided citizenship rights to persons of Indian origin living outside India. If such a person or his parents or grandparents was born in undivided India, he or she could become an Indian citizen. For this, the person had to register with the Indian diplomatic or consular representative in the country where he or she resided. This provision helped to maintain ties between India and its diaspora. Article 9 and Article 10. Article 9 deals with foreign citizenship. Article 9 states that any person who voluntarily acquires citizenship of another country shall cease to be an Indian citizen. India does not recognize dual citizenship in the true sense. Therefore, acquiring citizenship of another nation automatically results in the loss of Indian citizenship. This provision ensures exclusive allegiances to one country. Article 10 deals with continuance of citizenship. Article 10 guarantees that every person recognized as a citizen under the Constitution shall continue to remain a citizen. However, this continuance is subject to laws made by Parliament. This article provides stability and continuity in citizenship status. Next is Article 11, that is power of Parliament. Article 11 grants Parliament the authority to make laws concerning citizenship. Parliament can regulate acquisition, termination, renunciation, and all other matters related to citizenship. Using this power, Parliament enacted the Citizenship Act 1955. Next is Citizenship Act 1955. The Citizenship Act 1955 is the principal law governing citizenship in India. It provided detailed rules regarding acquisition and loss of citizenship. The Act has been amended several times to address changing circumstances. Major amendments occurred in 1986, 1992, 2003, 2005, 2015, and 2019. These amendments modified rules related to birth, descent, OCI status, and the Citizenship Amendment Act. Next is acquisition of citizenship. Under the Citizenship Act, citizenship can be acquired in 5 ways. These are: first, citizenship by birth; second, citizenship by descent; third, citizenship by registration; fourth, citizenship by naturalization; and fifth, citizenship by incorporation of territory. These methods provide legal pathways for obtaining Indian citizenship. Let's start with citizenship by birth. Citizenship by birth depends upon the date of birth and the citizenship status of parents. Between 26 January 1950 and 1 July 1987, every person born in India automatically became an Indian citizen. After later amendments, additional conditions were imposed regarding the citizenship status of parents. The objective was to prevent illegal migration while preserving genuine citizenship rights. Next is citizenship by descent. Citizenship by descent is granted to person born outside India whose parents are Indian citizens. The rules vary accordingly to the date of birth and amendments made to the Citizenship Act. In many cases, registration at an Indian consulate is required. This provision allows children of Indian citizens abroad to retain connections with India. Citizenship by registration. Certain categories of people can obtain citizenship through registration. These include persons of Indian origin residing in India, persons married to Indian citizens, and certain overseas Indians. Applicants must satisfy conditions prescribed by law. Registration is a simpler process than naturalization. Next is citizenship by naturalization. A foreigner can acquire Indian citizenship through naturalization. The applicant must fulfill qualifications such as good character, adequate knowledge of a language mentioned in the 8th schedule, and residence in India for a specified period. Naturalization is the most common method through which foreigners became Indian citizens. Last is citizenship by incorporation of territory. Here, when a new territory becomes part of India, the government of India may specify conditions under which its residents become Indian citizens. Example include Goa, Pondicherry, and Sikkim. This provision ensures smooth integration of newly acquired territories into the Indian Union. Now, termination of citizenship. Indian citizenship can be terminated in 3 ways. First, renunciation; second, termination; and third, derivation. These methods ensures that citizenship remains linked with loyalty and legal compliance. Let's start with renunciation first. Renunciation means voluntarily giving up Indian citizenship. An adult citizen may submit a declaration expressing the intention to surrender citizenship. Upon acceptance by the government, citizenship ceases. Minor children may also lose citizenship, although they can resume it upon attaining adulthood. Next is termination. Termination occurs when an Indian citizen voluntarily acquires citizenship of another country. Since India does not permit dual citizenship, Indian citizenship automatically comes to an end. This provision reflects the principle of exclusive national allegiance. Last is deprivation. Deprivation refers to compulsory withdrawal of citizenship by the government. It generally applies to the persons who acquired citizenship through registration or naturalization. Grounds include fraud, disloyalty to the constitution, illegal dealings with enemy states, imprisonment, or long residence abroad. This power safeguards national interests. Let's study about Overseas Citizens of India, that is OCI. The OCI scheme was introduced in 2005. It provides lifelong visa facility and multiple entry access to India. OCI cardholders are exempt from registration requirements for long stays in India. They enjoy several economic, educational, and cultural benefits. However, OCI is not dual citizenship. Okay? Let's study the limitations of OCI. OCI cardholders do not enjoy political rights. They cannot vote in elections, they cannot contest elections or hold constitutional offices such as president, vice president, governor, or judge of the Supreme Court and High Court. They are also restricted from purchasing agricultural land. Thus, OCI provides privileges but not full citizenship rights. Now we will see PIO and OCI merger. The PIO, that is Person of Indian Origin, and OCI scheme was merged in 2015. The objective was to simplify procedures and reduce confusion. After the merger, a single OCI card became available for overseas Indians. This strengthened India's engagement with its global diaspora. Now we will see Citizenship Amendment Act 2019. The Citizenship Amendment Act 2019 provides a fast-track route to Indian citizenship for Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians from Pakistan, Afghanistan, and Bangladesh. These individuals must have entered India before 31st December 2014. The Act reduced the required period of residence for naturalization from 11 years to 5 years for these groups. The government justified the law on humanitarian grounds for persecuted minorities. Now, significance of citizenship. Citizenship provides legal identity and recognition by the state. It enables participation in democratic processes. Citizens enjoy political rights, constitutional protections, and access to public opportunities. Citizenship strengthens national integration and promotes a sense of belonging. It is a cornerstone of democratic governance. Now we will see rights available only to citizens. Certain constitutional rights are exclusively available to Indian citizens. These include protection against discrimination under Article 15, equal opportunity in public employment under Article 16, freedom under Article 19, cultural and educational rights under Article 29 and 30. Voting rights and eligibility for constitutional offices are also reserved for citizens. Now we will see rights available to both citizens and foreigners. Some fundamental rights are available to all such persons, including foreigners also. These include equality before law under Article 14, protection of life and personal liberty under Article 21, freedom of religion and access to legal remedies. Thus, while political rights are citizen specific, many human rights are universally protected. Now we will see some important UPSC facts. Remember that citizenship provisions are contained in Part 2 of the Constitution, Article 5 to 11. India follows single citizenship, but US follow dual citizenship. Citizenship Act was enacted in 1955. OCI is not equivalent to dual citizenship. The Citizenship Amendment Act was enacted in 2019 and remains an important contemporary topic for UPSC examination. Okay? At last, Citizenship defines the legal bond between an individual and the state. The Constitution established the initial framework through Article 5 to 11, while the Citizenship Act 1955 provides detailed provision. Understanding citizenship is essential for comprehending rights, duties, governance, and national integration. For UPSC aspirants, this chapter is highly important for both prelims and mains examination and frequently appears in questions related to polity and governments. That's it for my side for this chapter. See you in the next video with next chapter, that is fundamental rights. तब तक के लिए जय हिंद.